supporting this bill because it makes sense. Effectively, this bill is about trying to make sure that the interests of investors are protected and making investors more confident in financial markets by ensuring that the trustees, statutory supervisors and unit trustees are capable of perform those functions effectively, and are accountable for any failure to perform those functions. So it's kind of simple, really, and it's to be applauded. Introduced at the end of 2009, this bill is a continuation of the great progress that Labor made in tidying up the financial services sector, including the review of financial products and providers. And as a member of the Commerce Select Committee, I look forward to scrutinising this somewhat lengthy and technical bill at the stage of the Select Committee. But I want to put on record that it is important. It's certainly not all that is required, but a tick to the government for introducing it. It's hugely important to build investor confidence in this country after the series of financial failures, the collapse of a number of finance companies and the number of people who have lost their hard-earned investments. And this bill follows on from the conclusion of both an IMF and World Bank report in 2004 and the consultations undertaken by the Ministry of Economic Development in the review of financial products and providers in 2006, which found that New Zealand places too much reliance on private supervisors such as corporate trustees, and that these supervisors and trustees often lack accountability. So this bill removes the automatic right for the 6 statutorily approved trustees to supervise issuers of debt and some investment schemes, and it introduces a licensing regime for trustees that will be run by the Securities Commission. The bill makes an offence to act as a trustee or statutory supervisor without a licence, so a person who commits such an offence is liable on summary conviction to a fine that doesn't exceed $300,000. A trustee or statutory supervisor or unit trustee must hold a licence that covers the debt security, participatory security or unit trust to which the appointment relates, and a licence holder must comply with every condition imposed on the licence. Licences will ensure the trustee, statutory supervisor or unit trustee is a body corporate, and their directors and senior managers must be of good character. This bill contains a number of provisions designed to ensure that trustees, statutory supervisors and unit trustees comply with their obligations, and the Securities Commission may seek pecuniary, penalty and compensatory orders against those who fail to comply. These clauses are designed to address the lack of capability and accountability of supervisors and trustees in the current system, as I've already said, and the fundamental role of the trustee, statutory supervisor or unit trustee is to ensure compliance with the terms of the trust deed or the offer of security. So when an issuer gets into difficulties, the trustee supervisor is supposed to take action, inform the investors or engage expert assistance or place the issuer into liquidation. But the finance company failures of 2006 to 2008 raised some important issues, and they were the lack of capability or capacity that trustees and supervisors and complexity of the securities that they supervise, weak trustees, the role of trustees and supervisors not being defined properly, and the potential for the lack of independence from the issuer. Trustees, supervisors are funded by the entities that they supervise. Also, weak accountability, where individual investors can take court action, but this is only the only form of accountability. So concerns have been raised in respect of similar issues relating to the performance of some statutory advisors of retirement villages as well. So I just want to read Just to put this in, give it some context to the situation that has resulted in this legislation, I want to read extracts from a couple of articles that appeared in late 2008. The first is from the Sunday Star Times, and it's titled "Business Reality Behind Smooth Assurances," written by Greg Ninnis. And it says that trustee companies are fond of emphasising the trust part of their name more than the company part, and this is reflected in the way that they promote themselves. Words such as integrity and experience often feature prominently in their promotional material, and they frequently promote themselves as a bulwark which can shelter a family from financial turmoil. But if you look beneath the veneer of prudently old-fashioned values, you will find a modern, commercially oriented business. And a core part of the activities of most trustee companies is managing family trusts, usually for many years after the person who established it has died. Often this will involve investing the trust's money to provide an income for its beneficiaries, and trustee companies could invest this money directly into property or shares or any number of the managed funds which are available to the general public, and sometimes they do. But many trustee companies have also formed their own managed funds into which they can channel money that they are investing on their clients' behalf. Where this happens, the trustee company gets fees, and its funds management arm generates also levies fees. A third leg of most trustee companies' business is acting as a corporate trustee. The law requires certain types of investment vehicles, such as finance company debentures, unit trusts and organisations, such as retirement villages, to have a trustee or statutory supervisor to protect investors' interests. And although the trustees' powers are limited in such situations, many people are questioning the value that they provide to the investing public. And then the article goes on. And just a brief excerpt from another article in the National Business Review, and also in 2008, in August 2008, written by Sarah MacDonald and Fiona Robertson, which started off by saying, in 2004, National Business Review published a double-page spread titled "A Matter of Trust," detailing major concerns held by many in the finance industry about the effectiveness of trustees at protecting retail investors. The carnage that has ensued since then, with more than $5 billion either frozen or lost completely in failed finance company, fund or mortgage trust investments, has done nothing to assuage those anxieties. And the consensus among finance and investment industry professionals that National Business Review spoke to is that trustees are underpaid, in some cases ineffectual, and in others plain incompetent. So the point I'm making is that this bill goes a long way to addressing this situation, but there is a lot more to be done. So in closing, I want to mention the work that's currently being done by my colleague, the Honourable Leanne Dalzell, previously the Minister of Commerce, who has recently launched a private members' bill to better protect investors. The Illegal Contracts, Unlawful Limitations on Regulators' Powers Amendment Bill will ensure that investors will not miss out on the benefits coming from a regulator taking action against an investment company that has breached the rule. And the issue was brought to her attention through the ING issues, where people were forced to sign away their rights to gain any benefit from someone else taking action against ING, including the regulator. Over $500 million was stranded in the ING product funds, with a lot of it representing the life savings of elderly people who continue to be angry and confused at the way that they were treated. So this bill makes a move to ensure that Kiwi investors get a fair deal worthy of consideration of Parliament, and I hope that members from all sides of the House give it a fair hearing if it's withdrawn from the ballot. And I think you've also heard tonight from my colleague, the Honourable David Parker, that there is also more to be done in terms of beefing up the Securities Commission to better regulate the space and not just rely on trustees. And that the Capital Development Task Force reported and recommended on this, and which mirrors similar things happening in the UK and Australia. So, as I said earlier, we support this bill, Mr. Speaker. We don't think that it goes far enough in terms of that there is a lot more to be done, but we think it's sensible and will protect investors and help restore confidence in the financial sector.
I call Jonathan Young.
Thank you, Mr. Speaker. I'm pleased to speak on the Securities Trustees